In the most bizarre thing we've seen yet in Judge Cannon's court, two elderly Trump supporters have filed a motion asking Judge Cannon to allow them to be part of the oral arguments in favor of Donald Trump in an important hearing over the constitutionality of the special counsel. These two senior citizens are not part of the case and are not even lawyers. This is what happens when a federal judge opens the floodgates and takes the extraordinary step of allowing outsiders to come on in and take over her courtroom. You're not going to believe this thing. Let's discuss. I'm Dave Aronberg, state attorney for Palm Beach County, aka the Florida lawman here on the MeidasTouch network. So you've heard of Judge Cannon's unusual decision to allow non-parties to not only submit amicus briefs, that's a friend of the court brief, which is allowed for outside parties. You can normally do that. But to go further and to actually allow outsiders to come on in and do the oral arguments, join with Trump's legal team to get 30 extra minutes to make an argument. And so Judge Cannon has allowed three separate groups, two right-wing groups to come on in and make an argument over the unconstitutionality of the special counsel law. And she's allowing one outside group to come on in and to join with Jack Smith and do an oral argument in favor of the special counsel law. She's allocated a day and a half for this, even though the issues involving the special counsel law have been decided by other federal judges over and over again. But Judge Cannon insists on reinventing the wheel and allowing these right-wing groups to come on in and make these arguments. In addition, by the way, to the arguments made by the parties themselves. You notice how you don't see a challenge by Republicans to Robert Hur, the special counsel who investigated Joe Biden and his retention of documents, the one who wrote that lengthy report saying that they couldn't prosecute Joe Biden in part because he's an old man with a poor memory. I mean, there wasn't a question about his constitutionality, right? Or the constitutionality of John Durham, the special counsel who Bill Barr asked to investigate the origins of the Russia probe. No questions about his constitutionality. Or David Weiss, the special counsel who is currently prosecuting Hunter Biden in Delaware and in California. You don't see these arguments from Republicans on those special counsels. But here, not only do you see the arguments, you see a federal judge entertaining the arguments and giving a day and a half to hear it out. To put this in perspective, the recent motion that Jack Smith made to try to modify the terms of Trump's pretrial release, after Donald Trump made those inflammatory comments about how Joe Biden was trying to kill him, how the White House was on a mission to assassinate Trump through the search warrant at Mar-a-Lago, even though the search warrant was using boilerplate language and Trump and his legal team were taking lines out of context. So after that, Jack Smith said, this is going to put law enforcement at risk. So Jack Smith filed a motion to try to stop Donald Trump from making these inflammatory comments saying that President Biden and the FBI were trying to assassinate him. I mean, after all, when the FBI went to search Mar-a-Lago, they made sure Trump was not there. They gave him special treatment to make sure he wasn't there. They dressed in plain clothes, not in any stormtrooper outfits, which is what the right wing is saying. And they were not coming in guns a-blazing. So the whole thing is a farce. It's a way to discredit federal law enforcement. Remember, back the blue, that was supposedly their slogan. And now Jack Smith's trying to protect law enforcement by stopping this overheated rhetoric. I remember what happened previously when Donald Trump went after the FBI and one of his extremist supporters showed up at the FBI headquarters in Cincinnati and shot the place up. So this is why Jack Smith filed the motion. And for that motion, after it was initially dismissed by Judge Cannon because Jack Smith had not conversed with the lawyers for Donald Trump, then Jack Smith refiled the motion and now Judge Cannon has set it on the calendar for a half a day. So Jack Smith's motion to change the terms of Donald Trump's pretrial release based on legitimate concerns has been given a few hours to argue. Meanwhile, this argument over the constitutionality of the special counsel, despite the fact that it's been litigated over and over again previously with other judges, that's given a day and a half. And not only that, the judge is allowing outsiders to come in and argue in addition to Trump's lawyers, in addition to Jack Smith. And now it's even gone totally loony because this is becoming a clown show. Let me show you the brief that was filed by two elderly non-lawyers who now want to argue for Donald Trump as well. They want to be given time, not only just submit paperwork, but to actually show up for the oral argument and argue against the special counsel. And here is their request. Jessica Nan Burke and Hilda Tobias Kennedy, disabled, pro se, indigent, private citizens, elderly. Whoa. Talk about identity politics, right? Democrats get bashed for identity politics. Look at this. You've got disabled, pro se. That means you're filing this on your own without a lawyer. Indigent, private citizen, elderly. They're checking lots of boxes here. Respectfully submit this informal motion for leave to present oral arguments as amici in support of President Trump's motion to dismiss the indictment based on the unlawful appointment and funding of special counsel Jack Smith, and submit an alternative resolution pursuant to the court order. And then they cite the court order that any amici wishing to present oral argument during this ring must seek leave of court to do so no later than June 3rd, 2024. So since they filed this motion 4 days after the deadline, they are SOL. As they say, you snooze, you lose. That's a legal expression. So you can't do it. But these individuals are asking for a special consideration because under the Americans with Disabilities Act, they say they are deserving of an accommodation, a reasonable accommodation that would allow them to blow through the deadlines and to be able to give the oral argument. We would want the court to respectfully see that the funding the state has used, legal or not, to prosecute the defendant is disproportional to the acts for which others in his same category and class have gone unpunished for the same crime as explained by the defendant filings. It says fillings, but I assume they meant filings, without the semantics by the opposition. That's a pretty hefty word salad that any lawyer could appreciate. Furthermore, our interest is in the misuse of government funds that do not support the people's interest of justice, but is more political in nature. In contrast, funding is greatly needed for crimes against seniors and the disabled, veterans, the elderly, abused, children, adults, etc., and the Department of Justice is grossly failing to use the people's money where it matters and should not be condoned for pursuing such a costly and dragged-out litigation that could be quickly resolved cheaply. Well, that I agree. I think that if you didn't have all these delays in this case, then this litigation could be done in a way that's less expensive and much faster and completed before the election. So perhaps if Judge Cannon did not slow walk this case, did not have endless hearings, did not allow motions like this and hearings that are open to the public where they can argue the motions themselves, then maybe this thing would have gone faster and money would be saved. Hilda Tobias Kennedy and me, Jessica Nan Burke, are not only renowned activists for progressive issues and disabled rights, but we are victims of discrimination as a disabled person, as you can see in the exhibits in support of the statement of interest. We cannot, in good conscience, see such a waste of money and miscarriage of justice go without words spoken, as we have suffered so greatly from our miscarriage of justice ourselves. We would also like to urge Congress to make some common sense legislation to stop this continued violation of removing sensitive documents without some kind of order, putting us all at risk. You're going to the wrong place if you're trying to get Congress to act. This is not the legislative branch. This is judiciary. And then I'm just going to wrap it up here. You don't have to go through the rest of this. Request for relief under the Americans with Disabilities Act. We did not see that a brief is required per the court's order, but as such, we are disabled and could not have one done in the time of June 2nd, 2024. So as a reasonable request under ADA, Hilda Tobias Kennedy and I, Jessica Nan Burke, are only submitting our request for oral argument. In the alternative, Jessica Nan Burke and Hilda Tobias Kennedy respectfully request additional time to file a brief in support of this motion. Essentially what they're saying is if you wanted to give an oral argument, you had to submit a brief and request permission to do so by June 2nd. They didn't do that. And now they're saying, well, forget the brief part. We're just going to ask to go straight to the oral argument. Forget the paperwork. We just want to go right to the podium. So this is the judiciary in 2024. We have Clarence Thomas taking a record amount of gifts from wealthy donors, failing to report it. We have Justice Alito and his wife flying the American flag upside down and flying another flag that has been co-opted by the January 6th defendants. And both of them continue to sit on January 6th related cases. Both of them refuse to recuse themselves from any Trump-related or January 6th cases. And you have Judge Cannon, who has been slow-walking this case and now has opened the floodgates to people like this, these non-lawyers. And these are motions that will be denied. There's no way that even Judge Cannon's going to allow this to happen. And Chief Justice Roberts has wondered why Americans have had such a low opinion of the judiciary, especially the Supreme Court. It's because of stuff like this, where you have a judge's order that is allowing non-parties to make oral arguments over a day and a half. And that also encourages folks like these two senior citizens to make a request that they be allowed to join in too. Not for any legal argument, just because they like Donald Trump and they think it's unfair that he is being prosecuted. This motion will be rejected. Even with Judge Cannon, this is going to be rejected. But the fact that we're even talking about it shows you that our system is in deep need of repair. And sadly, there's no evidence that the judiciary is going to heal itself. Chief Justice Roberts, are you listening? So that is the latest. I'm Dave Aronberg, aka the Florida Lawman, here on the MeidasTouch Network. If you like this video, please like it, subscribe, and share with a friend, and leave a comment below. I love reading your comments, and I'll see you next time.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.